Good morning. I'm Terrence Rebo from the Senior Lawyers Division of the state of New Mexico. We are here today to take the oral history of Judge Alan C. Torgerson. Judge, thank you very much for your willingness to sit for this oral history, and I welcome you.
It's my pleasure to be here, I think.
Well, we're going to find out real soon.
All right.
One of the things that I like to begin with, which is certainly not to skip over your earlier history, is what is your current status and what are you doing legal-wise in your career?
Well, there's a dispute about that between my wife and I. I maintain that I'm retired, and I retired from my previous retirement, but I'm still doing a little bit of work. As you may or may not know, I retired from the bench in 2014, and since that time, I was doing private mediations, working out of my home as my office, and my wife was my administrative assistant. And I did that part-time, but maybe 15-20% of what I would have done had I been working as a judge or in private practice. I'd do 4 or 5 mediations a month, sometimes 8 or 9, depending. And I also did some special master work, and occasionally somebody would talk me into doing an arbitration. And I decided in this year, actually, decided I was going to retire earlier, but COVID sort of intervened, and I decided that I didn't want to retire just yet. So in February, I put a notice in the bar bulletin saying, I'm moving on, I'm not going to do mediations anymore. I'll finish the ones I have, or if somebody asks me to do a mediation before, I picked the date of February 22nd, 22. And so that was my retirement from my retirement. But since then, people have called me and asked me if I could help them out, and I've always had a problem saying no, so I still occasionally do something, and I'm still working on, and have been since 2017 on the Gold King mine release case, and that's getting close to being wrapped up. There's still 1 or 2 remaining claims that need to be resolved and may end up going to trial, but I think my responsibilities are pretty much over. And I still do voluntary work as a special master in the McClendon case, which I started working on in 2005 when I was fairly new on the bench. That was one of the cases that was assigned to me. And so I did a mediation in that case in the fall of 2005. And we started at 9:30 in the morning. And I kept him at the courthouse until 11:30 at night, but we got the case settled. Subsequently, the settlement was set aside because of a dispute that the attorneys for the plaintiffs and plaintiff interveners had about whether or not there had been a misrepresentation. And there was another issue, went up to the 10th Circuit, came back, and the case was reassigned to Judge Parker. And I continued to work on the case because at that point, we were afraid it was going to explode into something equivalent to the riot at the state penitentiary in the 80s, because they were triple selling people. They had 2,800 people in the Metropolitan Detention Center, which Judge Parker and I had concluded, based on advice we got from the court-appointed expert on the operational part of the case, that you really could only effectively have 1,800 inmates, because you have to provide for special inmates who may need to be separated from other inmates. You'd have special pods for women, and so you couldn't necessarily fill every bed. And so while I was on the bench until I retired in 2014, I would meet with the lawyers regularly, mediate issues that came up if we could, and if not, Judge Parker would resolve them. And then I would meet with them monthly on a status conference just to make sure things were under control as best we could. I mean, I went from triple selling people, people sleeping in plastic beds in the common areas. It was just not a very good situation. Originally this suit started down when the jail was downtown, and then the county built with the city the Metropolitan Detention Center, and everybody thought, well, this is wonderful, now we got this big new facility. But it was full about a week after it opened because there had been housing inmates in various other facilities around the county, and so it was full from the beginning.
You had mentioned
issue.
You had mentioned the gold mine case. Now, some people may not know what that is. Everybody knows about the detention center. Okay. So tell us about the gold mine case a little.
All right. Well, I was going to tell you, let me just finish the detention center because you asked me what I was doing, and I after 10 years, I told Judge Parker I was going to retire. And he said, well, you can't retire until we get the Clinton case resolved. I said, okay, I'll stick around for another year. And I did. And then I said, I really want to retire, but here's what I'll do for you. If you appoint me special master, I'll continue doing what I'm doing, and then this is the mistake I made, and I won't charge for it. So since that time, I've spent hundreds of hours volunteering my time still working on this case, but things are much better now. There's still a lot of issues that need to be resolved. You'll still read about things in the paper on a regular basis, but it really is a good facility, but they're having problems with getting enough correctional officers, enough nurses, enough doctors. Like everybody else is having employment issues, and so things are still happening. But to answer your question, if people aren't familiar with the Gold King mine case, I would ask them to think back to August 15th, 2005, when they watched news that night. I read the newspaper the next morning, and you see the river coming out of San Juan County. Some people called it yellow, some people called it gold. But basically what happened is that there were thousands of old mines up in Colorado that are no longer being operated, and some of them have issues that the Environmental Protection Agency is trying to resolve regarding depositing. Materials were being deposited in the rivers, Animas River and San Juan River, from these mines before this spill, but just on a little gradual basis, and so that they were trying to figure out ways how to prevent this from happening. So they're working at this one particular mine called the Gold King mine, and the EPA was up there with some contractors, and they were trying to make preparations for work they were going to do. The ironic thing about it is somebody was actually videotaping this, and they were digging with a backhoe, and at one point they took a scoop and some gold-colored water started trickling out, and then it became more of a flow, and ultimately you can hear the person saying, what are we going to do now? And this is all on a video. So long story short, it contaminated the river, and the litigation involved the state of New Mexico, the state of Utah, the Navajo Nation, and hundreds of individuals, primarily all but about a dozen or so, who were members of the Navajo Nation, and how it either damaged their crops or they were afraid to feed their livestock. But for the Navajo Nation, the river is very sacred and had a lot of meaning for them culturally, and so there were various lawsuits filed in Utah, New Mexico, and was sent to the multiple district litigation panel and was sent back to New Mexico, and the cases were consolidated in New Mexico and assigned to Judge Johnson. And long story short, he and the attorneys agreed they needed a special master because he wouldn't have the time to give it the attention it needed, and nor would the magistrate judges assigned to the case. So I was asked to be the special master, and so I worked in that case, still working on that case. I started in September of 1917. It's the most fantastic case I've ever worked on, involving a lot of very challenging and difficult environmental issues, environmental laws, tort claims under the Federal Tort Claims Statute. But the good thing about it was they're absolutely wonderful lawyers from all across the country, from Department of Justice in Washington, D.C., lawyers from Chicago, from Denver, from Utah, Los Angeles. So at least one or two of them worked on the Deepwater Horizon case, which you may remember was a similar environmental disaster in the Gulf Coast several years ago. So made a movie out of that one. So it's been a fantastic experience and very challenging. And thank goodness I talked to him and they let me have one of my former law clerks help me out, or it would have been even more of a challenge than it was. But it's been a wonderful experience. Great lawyers, and the nice thing about them is I was able to work with them, and they would disagree, but very seldom were they disagreeable with each other. So it was a very interesting and fun case to work on.
Wonderful. So what you've been talking about is part of your responsibilities as a judge. When did you first become a judge?
March. The reason I said 22 to retire, I went on the bench on 3/3/03. It's one of those strange things. That's my license plate number. That's when I became a judge. How I became a judge is an interesting story, because when I was in law school and even when I was in private practice, I could never imagine myself having been a judge. I was going to be a trial lawyer, and I was a trial lawyer. But I was served on the United States Magistrate Merit Selection Panel, and so I knew the process and the people who were going through it. And I guess the real impetus came from my good friend, former Chief Judge John Conway. John and I knew each other since we tried a case together in Santa Fe many years ago. I think it was Petromez's first jury trial. And then I tried a case in front of him, and he became a judge. And then we were both members of the Albuquerque Country Club at the time, and we played golf together. And so he suggested to me one day, he said, "Have you ever thought about becoming a magistrate judge?" And I said, "No." But I said, "Well, I'll think about it." So then he piqued my interest, and so then I looked into it and I applied, and fortunately, because I knew most of the sitting U.S. District Court judges who make the decision, from having tried cases in front of them or with them, I was one of the people who were selected in 2003.
Wonderful. As a judge, and we all know that different judges have different philosophies, what was your philosophy as a judge?
Well, it's probably hard to put it into words, but my thought process was, one of the things I wanted to try to accomplish was to fix things that I didn't like about judges or what judges did from my perspective as a trial lawyer. So, for example, nobody likes, and maybe some people do, but I never liked the trailing dockets. You never knew for sure when you were going to go to trial, and it just created havoc. And if you had a busy practice and you were in a half dozen trailing dockets somewhere, it was hard to figure out where you were going to be. So I made sure I gave definite trial settings. In federal court, most of the motion practice is decided on the briefs and the response and the reply. But in situations where I thought it was necessary to have a hearing or get more information, rather than just scheduling the hearing and have the lawyers come over and regurgitate their briefing to me, I would let them know, I only need some help on this issue. This is what I want to talk to you about. And I think it made it easier for them to prepare and gave me the information I needed to resolve the case. And so I tried to be diligent, because I knew from my years of experience the worst thing that could happen to you is having a motion that needs to be resolved before you can move on in the case. And some judges sit on these things for a long time. So I tried to make sure that I was diligent and got these motions resolved as quickly as I could. And in many instances, as soon as the motion was filed, before it was even fully briefed, some of them were simpler things like scheduling issues. They couldn't agree on scheduling something, or who was going to do this first or that. So I would have my law clerk call them up, and we'd just have a telephone conference, and we'd talk about it, and I would resolve it and enter an order, and we didn't have to wait for all the briefing to get done. And obviously I tried to be fair and impartial, and you have to understand that it's very rare you can satisfy both sides. So you just have to not worry about that. You just have to do what you think is right based on the law and the facts. And occasionally you can make both sides happy. They just need a decision. They just need to know what the answer was so they could move on. But not very often could you satisfy both sides. So I tried to be diligent, and I tried to be friendly, but I was pretty much a no-nonsense judge. I think that was probably my reputation. So I expected people to be professional. I had 3 rules, very simple: be on time, be prepared, and be professional. That's all I ask of you. And if people weren't on time, they may have to make a donation to their favorite charity. If they didn't have one, I would volunteer one for them. And if the thing that bothered me as a private attorney and bothered me when I was on the bench is in motion practice, lawyers can't help themselves about saying ad hominem comments since all the other lawyers followed them saying something. And so when that would happen, I would just say, well, Mr. Revo, you can keep talking, but I'm going to stop listening until you stop making these ugly comments about opposing counsel. Just tell me what happened. Here's all you need to know. What is the issue? How do you want me to rule? And what facts or law or authorities do you have to support your position? That's why we're here. I don't need to know about all this other stuff. So that was sort of my philosophy, I guess.
Well, that brings up another issue for me, and this was so important. But I understood that the judges often felt like they were herding cats when it came to getting the lawyers to do what they needed to do to be able to follow your 3 rules. What was your experience?
Well, I'll have to tell you, I'll tell you 3 things about that. Number 1, when I first came to Albuquerque, I worked with Juan Burciago, as you know, later on became U.S. District Judge. And Judge Burciago taught me that when a judge enters an order, you comply with the order. When the judge says you comply with the order by X date, you comply with the order by X date. So that's sort of the way I live by. And I think the problem is, and I don't mean to be critical of the state court judges because they have a lot of work to do, but the problem is lawyers are so used to getting extensions of time and getting things vacated in state court that it's kind of a shock when they come to federal court and the judge says, no, that's not going to happen. And so I'll give you another example. When I would schedule mediations, I'd ask the lawyers to submit me position papers by a certain date. Well, as it turned out, my administrative assistant was spending half her time contacting lawyers and saying, we haven't gotten your position paper yet. So I added a footnote to my order. It says, you'll be fined $100 every day that your position paper is late. And that was the end of the problem. But the one disappointment that I had when I went on the bench was I was really disappointed in the quality of the briefing. I was so used to the kind of work that I would get from the associates in my law firm, and so often the briefing wasn't even helpful. Fortunately, that's the advantage of being a federal judge and the state court judge. I had 2 law clerks who could do research and could find the cases to support or not support whatever the issue was. But I have to say I was disappointed. Not always. I mean, maybe 10% of the time. But I was really surprised to see some of the briefing that I saw.
In terms of the quality of the work.
Right. Yeah. The other one thing that I think is interesting, that comparing state court to federal court, most plaintiffs' lawyers, and you can tell me whether or not you agree, but most plaintiffs' lawyers did not like to go to federal court. And I won't mention a name, but more than one has told me that your case goes to federal court and it dies in federal court.
That's right.
Because federal court judges actually grant motions for summary judgment. And I always thought, well, maybe it's because federal judges make lawyers do things when they're supposed to do them and enforce the rules and so forth. But the answer I would get generally was, we want, as our New Mexico Supreme Court has made clear, we want the sun to shine in on these cases, and we'd like the jury to decide these cases, and unless it's something that's pretty obvious. And in federal court, we didn't have that problem.
Yeah, and that was the common wisdom amongst plaintiffs' attorneys, is that federal court was the place that your plaintiff's case went to die.
Right.
Right? And so we really tried to stay out of federal court. And yet, once you were in federal court and you became accustomed to the rules and the procedures and the way things were done, I thought it was much easier.
That was my preference. When I was in private practice, I much preferred practicing in federal court than in state court for that reason. I mean, the rules are there for a reason, judges enter orders for a reason, and if you just comply with them and follow them, it's really helpful. So, but.
You talked about mediation a little while ago. After you retired for the first time, you started a mediation practice. Can you talk to us a little bit about what that was like for you, not only as, and I'm backtracking a little bit, because you did mediations as a federal magistrate, but maybe you could compare and contrast what it was like doing mediations in the federal system as opposed to the private system.
Okay. Well, you've been around long enough to know. I can't say for sure, but my best guess is we started doing mediations in New Mexico in the late 80s or early 90s in state court. And so I represented dozens of people at mediations before I became a judge. And then when I was a judge, one of the responsibilities I had was to deal with mediations in my cases. But I would frequently do mediations in other judges' cases because the lawyers would ask me to, and because I really enjoyed doing them. Not all the judges liked doing them, and some judges were better at it than others. But the answer to your question is, it's much easier to be a mediator when you're a judge. I wouldn't wear my black robe, but I still had that going for me, and you could be a little more direct and encourage the people to settle with a little more clout than as a private mediator.
I seem to remember that.
But I found it really not much different in private mediation, because to be successful at a mediation, I would always tell the parties, both when I was on the bench and private practice, three things have to happen. You have to have the right people, so you've got the plaintiff and the plaintiff's lawyer. You have to have the defendant's lawyer and the appropriate person from the insurance company, if it's that kind of a case, or from the defendant, the authority to settle. The parties have to be there in good faith, and I always tell the people that means you're there with a hope, intent, and purpose of settling the case. And most important things, you have to be willing to compromise. Well, on the first issue, I would make sure in my order that somebody had to be there with full authority to settle the case, and you would get hassles with the lawyers about that from time to time. The most interesting thing that happened is I did that in a case involving the Department of Justice, and I got this fairly lengthy letter back from somebody from the Department of Justice saying, well, ultimately Congress has ultimate authority to settle this case, so you don't expect the members of Congress to show up in your courtroom. And so we worked that out. So, and the second thing is good faith. Well, if lawyers are in front of a judge and the judge has scheduled the mediation, you would hope they're much more interested in getting the case settled and being there in good faith. But occasionally somebody would show up, they weren't very well prepared, or I didn't think they were participating in good faith. And so then we would have another hearing and make the same decision about what charity they wanted to contribute to. That didn't happen very often, but it did happen. Or I would assess the attorney's fees and costs of the other side for showing up not at the mediation and not being productive. But in private practice, you don't have those capabilities, so you have to be much more amenable to doing things that that are consensual, and scheduling is usually not, well, scheduling is, to me, I'd have never understood why scheduling is an issue with the lawyers. So often I was on the bench, there was an issue about scheduling. Setting up mediations would be an issue about scheduling, particularly more recently, because lawyers do everything by email or text, and they say, okay, I'll make my client available on these dates. Are you available? And then they get, no, I'm not available, so I'm available on those dates. And so when that happened and I was on the bench or in a private meeting, I'd say, let's do a telephone conference. Get your calendars out and we'll decide this in 30 seconds, which is what usually happened. But I just never understood why that happens. But in terms of getting the case settled, three things have to happen for the mediator to be a good mediator. You have to be prepared, you have to be patient, and you have to be persistent. And that's where my Norwegian background comes in, the persistent part. I'm pretty persistent about sticking in there until we get the job done. And it's easier for me to work with the defendants, and particularly the defendants where there's insurance adjusters available, because I did that for more than 30 years. I could speak their language and know how they do things. And with respect to the plaintiffs, it's more developing a relationship with the plaintiff. And I'll have to say there were many times, and by the end of the mediation, I thought the plaintiff was listening more to me than they were listening to their own lawyer, because I would tell them about my experience and what could happen. And so it's better to settle if you can. I can make you settle. You're entitled to have your day in court, and develop a little rapport with them, and eventually you can get the case settled.
Well, oftentimes it's much better as a plaintiff's attorney to hear your client's weak points from the mediator,
Yeah.
as opposed to from you.
Yeah, I'll have to say my approach with the lawyers is somewhat adversarial. I would press on, you can tell me what your strengths are.
Oh, really? I never noticed that.
I wanted to talk about your weaknesses. How are you going to deal with this? And I would do it in front of their client. And with respect to the parties, that was much more an avuncular approach. I was trying to be a little more friendly, but I had probably had a reputation, particularly when I was on the bench, as being a little tough on the lawyers at mediations, but it worked, and we got a large majority. I think when I was on the bench, I got 70% of the cases settled. So it worked.
So were you really doing a devil's advocate type of job during the mediations?
Well, I would tell the plaintiffs that, because I would tell them that it's my job to talk to both sides about the case. We talk about the strengths and the weaknesses, and you want to develop a little empathy with the plaintiff in particular, because you want to let them know that you believe them, you believe how they've been injured, but we have to decide whether or not it's a type of injury that can be compensable under the law. And I found out in doing this that if you can establish a relationship with the plaintiff particularly, and let them know how sincere you are and that you really care about what happens to them, then they'll listen to you, because they don't really care about how much you know until they know how much you care. And if you can establish that, it works. And then I would tell them up front that I'm going to be twisting your arm a little bit to get you to compromise. I'm going to do the same thing in the other room, because that's the only way we can get the case settled. And I would tell them that my motto when I do mediations is, I'm not happy until you're not happy. And it's on the bottom of my letterhead, and that's sort of a philosophy I developed over the years after working with the federal government and the folks that are responsible for running the buildings that you're in, and you want to get a wall painted. I could hire a high school kid and buy a gallon of paint and get it done for $50. But they want to go through some process, get a bunch of bids, and spend $3,000. So it could be a frustrating experience.
Yeah, let's go back to this. I'm not happy until you're unhappy. That's something that plaintiff's attorneys really do understand. Is if you have two parties at a mediation or a settlement conference of any type, that you really don't have a good settlement unless both parties are unhappy.
Yeah, well, that's right. No, I would tell them, most leaders say the same thing. If somebody walks out of here thinking they got a great deal, then I haven't done my job. I mean, it's as simple as that. So that's very true. But some of the times, quite frankly, and sometimes people let me know ahead of time, or it'll become painfully obvious during the mediation, the lawyers don't have control of their clients, and that's where they appreciate my help. I had a case recently. I won't mention any names, but this case involved somebody who had rented a facility and was running a restaurant, and had put down a $15,000 deposit to pay for any damage that might have been done during the course of the lease. The restaurant didn't work out. They agreed to terminate the arrangement, and one side wanted the $15,000 back, and the other side said, "No, I don't think you're entitled to all of it. We can talk about it." But we immediately both went to both lawyers. By the time it came to me for mediation, one of the sides had spent $50,000 fighting over a $15,000 issue, and the other one, I didn't get a specific number, but and they were just as frustrated with their clients as I were. But they're two very successful businessmen who just wanted to have their way. So we did the mediation, and I told the lawyers, these are two very successful, wealthy businessmen who are just wasting their money. And so I recommended a number, and ultimately they were able to get their clients to agree to a number. And that happens frequently when there's an issue like that. Parties will ask for a mediator's number, and it works a surprising number of times.
You've done so many mediations, both as a judge and as a private mediator. When mediations fail, from your perspective, what seems to be the reasons?
Well, I would say the primary reason is it may not be an appropriate time. It may be too early, or there may be some issue that needs to be resolved, or it may be simply be one side or the other has not really evaluated their case. When I was on the bench, so often one side or the other would say, "Well, we've got a motion for summary judgment pending. We need to get that decision before we can have a mediation." And I said, "That's not going to happen. We're going to have a mediation. You can evaluate what you think the chances of, are you winning on that motion or not, but we're going to have our mediation and we get the case settled anyway." So that's frequently an issue. And there are some times when they really do need to do some more work and get an issue resolved before they can settle the case. But other times it's just not. I'm not sure one side really wants to settle, because now a lot of times the judges schedule mediations, and one side or the other either doesn't want to settle or doesn't think it's appropriate to settle at that point in time. And some lawyers think and I've had this issue more so with lawyers from Texas than New Mexico, that they just think it's a perfunctory procedure they have to go through in order to get their case to trial, and don't really care whether the case settles or not. But so there are any number of reasons. But what I will often do in those cases is, okay, well, let's step back, get your issue resolved, and we'll get together again later on, and then that frequently works. Or if we don't get the case settled, I'll say, you all think about it, and if you change your mind, let me know. And one side or the other will call me and say, "Judge, we really want to settle the case. We don't want the other side to know we want to settle the case." And so I say, "Okay, I'll deal with it for you." And I would just call the other side and say, "I've been wondering if you got your case settled yet. What do you think about getting together again?" And that often works also.
One of the things about practicing law that I've seen is that the public doesn't really know and understand what lawyers and judges go through to try and get their cases resolved, whether it resolves through a telephone call or a mediation like you've described, or even a trial. in terms of the public's need to know, the public's knowledge of what judges do, what, if anything, did you do to try and expand that?
Well, I'm not sure that I could say that I did anything to expand that particular aspect. The problem with the public's perception is it comes from watching TV, and things don't happen. You watch a TV show, and within an hour they've had the incident happen, they've had a little bit of work, and they have a trial, and usually have a smoking gun that their side didn't anticipate. It just doesn't happen that way. And I think another misperception that the public has is that if you're a judge, then you know everything, and you should be able to resolve this. And in reality, I discovered this when I went on the bench. There were so many federal laws I'd never heard of and that I had to become familiar with. And to a large extent, you rely on the lawyers who are maybe more experienced practicing in that area to educate you, or you rely on your law clerks, or you just educate yourself. But I think the public may have a false impression that because you're a judge, you know everything, and you don't.
Mm-hmm.
And certainly I didn't.
I'm sure there's one or two people who accused you of that.
Probably, not maybe to my face, but.
We've talked an awful lot about law and judging and mediations. I'd like to go back to where it all started. Where did you grow up? What was your family like? When and what made the decision for you to go to law school?
Okay, I'll start with November 8th, 1945. I was born in the hospital in Fort Dodge, Iowa. I was the last of 8 children and the only one to be born in the hospital. We lived on a small farm that my parents rented from the owner, and we self-sustained basically. But one thing about my birth is my mother had I don't know the issue, if I ever knew the issue, during the pregnancy. And so I was born prematurely. I weighed 5 pounds and 13 ounces when I was born. I don't remember how many weeks early I was born, but back then they didn't have all the fancy stuff to take care of newborns that they do now. They just put me under an incubator and kind of hoped I survived, and I did. And my mother was so grateful. That's how I got my middle name, Cloyce. She named me after the doctor who took care of me and her while we were in the hospital. So back to the beginning. So we lived on this farm, and I lived in this farm until I was 8 years old, and my job was to do my share of things. I would pick the eggs, slop the hogs, bring the cattle in, help clean out the barn, and other various things like that. I was, by the time I was 8 years old, I could drive a tractor. I mean, that's just part of what you did when you were on the farm. And I remember one of the most disappointing things. I was in 4-H, and you pick out a calf when it's young, and you raise it, you take care of it, you go to the fair, and you hope you get a blue ribbon. And then if somebody else buys it, or if they don't, you come home, and then they butcher it, and that's that's your meat for the year, or the part of the year. And so you get accustomed to life and death on the farm in a way that people who never grew up on a farm don't have an appreciation for. But speaking of life and death, unfortunately, my father had a heart attack when he was 54 years old. And back then, you'd go in the hospital, and you stay in a while, and you recover, and you go back to work. And unfortunately, he had another heart attack a year later, and he didn't survive that heart attack. Now, if this had happened now, he would have had, I'm sure, a bypass and lived another 25 or 30 years. So I really have very few memories of my father, and fortunately, I remember a couple of things. He got his hand stuck in a corn picker and lost most of his fingers on one of his hand. I remember that. And I remember a couple of other things, but I remember the night before he died, I was at the hospital, and my mom was up in the hospital room, and I was with an aunt or an uncle, and they weren't allowing kids to go up to the hospital room. And my uncle says, "Come on, I'm going to take you up." So he took me up to the room where my father was, and this is the last conversation I remember having with my father. He said, "What are you doing up here? You're not supposed to be up here." And so that was that. But because of that, there was my mother, me. I had a brother who was 6 years older, so I was 8, so he was 14. I had another brother who was 6 years older than him, who was 20, and we couldn't operate the farm, so we sold our farm machinery and animals and moved to this little town called Bodai, which had like 500 people in it. There was two restaurants, a bar, grocery store, and a post office. So one of my sisters and my brother and my mom tried to operate this restaurant, and that didn't work. So for several years, my mom and I and my closest age brother lived on government assistance and rented rooms from places, and that's how we got by. But I don't remember it being a bad time. My mom was a very good cook, took very good care of me. I was happy. I was involved in playing sports and doing things. But then she got remarried, and we moved to Rockford, Illinois, which is where I went to high school. And then I went to undergraduate at Northern Illinois University and to law school at the University of Illinois. And to answer your question, the thought of becoming a lawyer had never occurred to me. I never met a lawyer until I went to law school. And the decision to go to law school was sort of serendipitous. I was in my last year as an undergrad. Back then, you went to school 4 years and not 6 years or 8 years, however long it takes now. And I must have been Christmas vacation. I was back home visiting with my then girlfriend, standing in the kitchen talking to her mother, and she knew I was about to graduate. And she said, have you thought about what you're going to do when you graduate? The wheels started turning. I mean, I was majoring in political science. I had a minor in economics and history, and I didn't really know what I was going to do. I thought maybe I'd end up being a teacher and a coach basketball or baseball, which is the sports that I played in. And so she said, well, you ever thought of becoming a lawyer? I said, no, but that's a very good idea. So I scrambled, and I applied to 2 or 3 law schools. And so I had to go take the law school admissions test. And back then, you didn't study a bunch of stuff. You prepare for it. You just went and took the test. And I'll tell you, it was so far. I don't know how I ever got into law school, because one of my fraternity brothers says the test is being administered in Chicago. He said, well, why don't you come stay with me? You live in one of the suburbs, and you won't have to drive so far to get where the law school admissions test is going to be administered. And I said, okay, that sounds like a great idea. So I did. So we're sitting there, and I had a meal with his father. He said, why don't we go out and get a beer? You can relax before you take the law school admissions test. So, one beer led to another, and led to maybe another, and I remember getting up and driving there. I had such a headache when I took the law school admissions test. Fortunately, I did well enough, and I had good enough grades that I got admitted to the University of Illinois, which back then was, and it still is, but a very good law school, but it was one of the top 20 law schools in the country, and so I was very fortunate.
So you finished law school, and did you practice in Chicago?
Yes. My first job in my graduate in 1970 was I got a job for Madison County Legal Services in Alton, Illinois, which is just across the river from St. Louis, a very nice little town, for the princely sum of $10,000, and I was delighted to get the job. And so I did that for a year or so, and then I decided my then wife's family lived in Chicago, and we decided we'd go back to Chicago. So I got a job with a couple of 3 lawyers who'd broken off from another firm, very good lawyers. The head of the firm was generally considered the best defense lawyer in Chicago at the time, so I was very fortunate to get a job with that law firm. And as it turns out, one of my best buddies from law school also got a job with that law firm, and so I worked there for a better part of a little over 3 years, and doing insurance defense work. And I was fortunate to work with this fellow who was very detail oriented. He went to the University of Michigan Law School, was very, very smart. And he had me do in all of his cases something called initial case analysis, which he'd put the whole case together in about 3 pages very succinctly. And he would correct me on it. And that's was very helpful to me in my career later on, to be able to condense information and what you needed to know into a smaller.
It's kind of like a litigation plan.
Yeah, well, yeah, an evaluation and a plan. Exactly, that's what it was. Yeah, and then I got tired of winters in Chicago. My office was maybe 4 blocks from the courthouse, and every day I'd go to motion practice. And I don't know if you know what totes are, but totes are rubbers that you put over your shoes. You probably know from Buffalo, you probably know what they are. So I wore totes from, my goal was to get to my birthday by November 8th without having to wear a top coat, but never made it. So I'd have a top coat, I'd have a scarf around my neck, I'd have one of those Russian fur hats, I'd have gloves, and I'd have my totes on. And literally, there were days I'd have to go storefront to storefront because that wind off of Lake Michigan with that cold temperature just sucked the air right out of you. And so my wife and I said, that's enough. Let's think about moving somewhere else. So we thought about various places. We thought about Atlanta, and we thought about Phoenix, Denver. I didn't really want to go to California. And just so happens the people that were living next door to me in the apartment complex where we lived had a son who was going to school at the University of New Mexico, and he came home for Thanksgiving or Christmas or something. Started talking about New Mexico and how wonderful it was, and so I said to my wife, let's take a trip to New Mexico. So we did, and sort of liked it because what appealed to me is instead of walking down the street and looking and seeing buildings, you could see the blue sky, you could see the mountains, and so, long story short, we decided to come to New Mexico. So this is another interesting story. So I applied to take the bar exam, and I'm sitting in my office one day, and this lawyer that I told you about, that was my mentor that I was working with, says, come to my house, I want to talk to you about something. I said, okay. So I walked down there, and he says, I got this letter from the New Mexico State Bar Association wanting to know about your employment. I said, oh, yeah, I was thinking about taking the bar exam out there because my mother was thinking about investing in some. So I made up some story because I wasn't ready to leave just yet. So I said, well, okay. And so it was another 6 months. And I was working while I was studying for the New Mexico bar exam. So I'm working, at night everywhere. I would have these BRI, I think is the name of the book, that in my spare time I would be studying for the bar exam while I was not working on something at work. And fortunately, I passed the bar exam. It was interesting. It took a long time because I took it in 1974, and that was the first year of the multi-state exam. And the Board of Bar Examiners couldn't figure out how to evaluate that. I said it was a problem elsewhere in the country also, but long story short, I think I took the bar exam in January. I didn't get the results until June. So I don't know how long. I don't think folks wait nearly that long now, but that was put a crimp in my plans about when I was going to move also, because I wanted to make sure I had passed the bar exam so I could get a job before I moved. And unfortunately, I did. And
speaking of jobs, what was your first job?
First job here is with the firm of Esri, Burciaga, and Parrish, all wonderful people. I worked with Juan Burciaga, who you know is later on becoming a United States District Court judge. And unfortunately, I think Juan maybe had not the greatest reputation with lawyers. He was a pretty tough taskmaster. But I got along fine with him, working with him. And he was a great mentor to me. As I said, he one of the things I learned from him was to follow court orders and do it when they say to do it. And he was in the Board of Bar Examiners and also involved in bar deals, association matters, and so I kind of learned that from him too. But unfortunately, at some point after a year or so, I thought maybe I wanted to try something else with a little bit bigger firm. And so I'd gotten some information from a friend of mine about the Modrell firm, and then somebody else mentioned something about what then was Schaefer, Butt, Thornton, and Jones, which is now Butt, Thornton, and Bear. And so I talked to both of those, and I had opportunity to go to work there, and I ultimately decided to go to work at the Schaefer, Butt, Thornton firm because it was a little bit smaller. I thought maybe I wanted to have more of a say in how the firm developed, and so then I was presented with another issue of having to tell somebody something, and so I went in to talk to Mr. Burciaga, and well, I guess I should tell you that like 2 or 3 months before that, I had the firm's expense gone to what you now call a continuing legal education program at Berkeley Law School in California, and so that's fresh in the back of Mr. Burciaga's mind while I'm having this conversation. So I said, I'm sorry to tell you this, but I've decided that I'm going to take a job with another firm, and I feel bad about it because I really enjoyed working with you, and I enjoyed working with the firm, and I don't want to leave you on alert, so I'll be happy to stick around for a couple of weeks to help you with the transition. He looked across the table and said to me, "You can leave tomorrow." So I did. And later on, I tried a case in front of Judge Burciaga, and believe me, if he was hard on most lawyers, he was really hard on me. And I'll tell you one example. It was an interesting case, products liability case. I represented the manufacturer of these racing suits that dragsters wear when they're racing. They have their helmets on, and these supposedly fireproof suits. Well, this guy was doing one of these, and he claims the suit got on fire in some way, and he sustained burn injuries. I won't mention the name of the lawyer, but so we're trying the case, and he had this old expert witness from Northwest somewhere, or Oregon or somewhere. And it was a judge trial. So we're in the courtroom, and he has we cut out a piece of the material that the suit was made out of, and he has his expert have it on something to hold it, and the piece dangling down. And he wants to show that it will catch on fire. So he lights a match, and he holds it there. Nothing happens. Puts that match down. Gets a second one. Lights it. Nothing happens. So finally, Judge Burciaga says, don't mention the lawyer's name, but tell your client to stop trying to set the courthouse on fire. Something like that. I don't remember his exact word, but he's seen all he needs to see about that demonstration. Yeah. So later on in the trial, I had my expert witness from the company, Simpson, is still well known in the racing industry. And we had a piece that was still the sleeve of the suit. So I said, Judge, I want to do a demonstration too, but I would suggest we do it in the parking lot underneath the courthouse, if that's okay with you. And he said, okay. So we all go down to the parking underneath the courthouse. My guy puts his sleeve of the suit on. He lights a blowtorch, and he goes, nah, 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 nah. Nothing happens. End of case. But so that's the only case I tried in front of Judge Burciaga. But fortunately, I won that case. But he was tough on me as well as other people.
So it sounds like that with the exception of the legal aid job, you did mostly insurance defense work through your entire private career.
My entire career, with one exception. Well, there were maybe more minor exceptions, but one exception was I tried a case in Valencia County involving somebody who worked for a restaurant, as I recall, and he was driving back and forth, either coming from Farmington to Albuquerque or going from Albuquerque to Farmington on that old highway, and somebody had let their horses loose, and he ran into a horse and sustained a brain injury. And so we tried that case. I wish I could remember. Oh, Judge Bowers from Los Lunas was the judge. And this is one of the first brain injury cases I worked on. I had this guy, I think his name was Jack Rhodes, who was one of the original neuropsychologists that would testify in cases like that. And I remember when, I think, is Bowers the right name? I can't remember the name of this judge. I'm pretty sure it was him, but I remember I actually walked into the courtroom and he's wearing this white hat, and for some reason he said, "Oh, here comes the man in the white hat," and that was kind of I thought a nice thing to say on behalf of my expert. But we won that case, and at that time it was the largest verdict in Valencia County. It was in the hundreds of thousands of dollars. I'm sure it's been eclipsed many times over since then. But the other thing I remember about that case, we were trying in the old courthouse, and there's a bat flying around, and the jurors are worried about this bat while they're trying to listen to the evidence. So these are only things that can happen in courthouses in New Mexico. But
one of the things we lawyers are noted for is having a lot of war stories. And so let me ask you about some of the more interesting cases that you participated in.
Okay. Well, I was fortunate to be able to try cases against some of New Mexico's finest plaintiffs' lawyers. You will recognize some of these names. Matt Zamora was probably Northern New Mexico's finest trial lawyer at the time. Dick Ransom, Bill Carpenter, Turner Branch. I tried cases against Steve Schoenberg, medical malpractice lawyer, was very successful. Carl Bettinger, I think he and I tried his first case against each other. His first case that I was involved in. And Bill Carpenter, I'm pretty sure, tried the first, he and I tried the first case in which comparative fault was something that needed to be decided. And I remember the judge was Jack Love, and one of our jurors was Bert Cosgrove, who you may remember went on to become a judge. And I'll tell you one story that's related to Judge Cosgrove. This is when he became a judge. He had this practice. If you made an objection, you had to write it out on a little postcard thing and take it up the bench and show it to him, and then he would rule on it, but he didn't want you to make verbal objections. So we did that for the first day, and finally said, "Judge, this is just really cumbersome, it's not working." It would be, because the opposing counsel and I both agreed, so it would be okay if we just followed the normal procedure and make objections, and he said, okay, so we talked to him about that. But the interesting part of the case was I was representing Willie Banks. Willie Banks went to Albuquerque High School, and he played for the Lobos. He was the most popular basketball player maybe the Lobos have ever had, except for later on Greg Banks, who also went to Albuquerque High School. But I was representing Willie Banks. He got involved in a little accident, and he was being sued in the Stern basketball season. So I presented for a deposition, and this trial came up. So I called the coach, and I said, "Coach, I'm sorry, but I've got to have Willie available for the next 2 or 3 days." And he said, "Okay, not a problem." So I get Willie there, and we're picking the jury. We're doing voir dire. And you always ask questions, and one of the traditional questions is there any reason you think you couldn't be fair and impartial to both sides? And of course, nobody ever raises their hand because nobody ever thinks they can't be fair and impartial. But about 3 people raised their hand, and I'm thinking, oh boy, where is this going? But you have to ask.
Right.
So I asked one of the first ones, "Excuse me, Mr. Smith, do you mind telling me why you raised your hand?" He says, "Yes." I said, "Well, why?" He says, "Well, I could never rule against Willie Banks." And that was the same response I got from the other two. So we won that case also, but not necessarily because of me, but Willie was very popular. So I'll tell you a couple of other interesting stories about, I should just tell you about cases I won because I didn't win every case. But I'll tell you a couple of stories about malpractice cases, and I won't mention the lawyers. One was a situation involving a doctor in a small community, and like most small communities, it had a small hospital, but it wasn't busy enough to have a full-time emergency room physician on duty, so the local doctors would take turns covering the emergency room. So I represented this doctor, and he was a general practitioner. He wasn't even an OBGYN, but like a lot of general practitioners back then, he would deliver babies. So he had this patient, and he was taking care of her during the early part of her pregnancy, and she insisted that she wanted to have the baby delivered at home by a midwife. And he said, I don't know whether she had some condition that he was concerned about or it was her age, but he said, I don't recommend that. I don't think you should do that. But she insisted. He said, well, okay, then I'm no longer going to be your doctor. So she went to a midwife. And ultimately, she was about to have the baby. The midwife came out, and there was a problem. And I don't remember now whether they couldn't deliver the baby or delivered the baby and the baby was in distress, but they came down to this little hospital. As it would turn out, my doctor, who was her doctor and said, I don't want to be involved in this case anymore, was on call that night. So he responded, went to the emergency room, and they weren't able to save the baby, unfortunately. So there's a lawsuit. And so we tried this case. This is the only case that Harris Hartz and I tried together. But we're trying this case, and a very well-known plaintiff's lawyer. And we finished the case, we finished closing argument. Judge reads the instructions and says to the jury, okay, it's time for you to go deliberate. And so they go to the jury room, and I'm cleaning up my mess at my table and going to the restroom and doing whatever you do while you're waiting for a jury. And I went into the clerk's office just to talk to somebody to pass the time. And the bailiff comes in and says, we've got a verdict. And I'm sure he's joking with me because it's a very short period of time. He said, no, I'm serious. The jury has reached a verdict. I said, well, okay. So I went back into the courtroom. They rounded up the plaintiff's lawyer, and they came back and they ruled in favor of my doctor. And the case was appealed, and one of the issues on appeal was that jury couldn't possibly have considered all the evidence because I don't remember the exact time. For some reason, 7.5 minutes sticks in my mind. It could have been 15 minutes, but it wasn't very long. But the appellate court upheld the ruling in our favor. In another case, and this is, much of my career I did a lot of personal injury, wrongful death, products liability, but more than anything I represented doctors and other healthcare providers who were being sued for malpractice. So I represented this was an OBGYN doctor, and he was also, I think he was from Farmington. And like most doctors, he didn't like lawyers and didn't like being sued. And he didn't have the greatest bedside manner to begin with, or much of a personality. But, you could deal with that. I told him, like I'd always tell my doctors, I know they take this very personally, and I can appreciate that, but I just want you to understand there's only two kinds of doctors. There are those who have been sued and those who are going to get sued. So it just kind of comes with the territory. So we're in trial, and this is another very well-known plaintiff's lawyer. And this is another unfortunate case. It's a lady who was pregnant and near term, and she got an infection. I think she had scratched the back of her head or something and got an infection. It got into her system, got into the baby's system. Long story short, they both died. That's probably a defensible case. I thought it was a defensible case. And we had good experts on both sides. So during the trial, it gets down to the point where I've called my doctor on direct, and he's being cross-examined. And the plaintiff's lawyer wasn't being necessarily rude or ugly, but my doctor just wanted to show him that he knew more than him. He didn't know what he was talking about. And this went on for an hour and a half. And I didn't like him, and I didn't think the jury liked him. So we finished the trial, and it was late in the afternoon, so we went home for the day, and I had another associate with me at the trial, and I couldn't come back the next day. I cleared this with the judge ahead of time because I was going with a friend of mine, and we took a team of high school women's basketball players to Europe, and we traveled around and played basketball against the various kibbutzes and so forth. And I was leaving at 5 o'clock the next morning, so I wasn't going to get the verdict. But long story short, the jury ruled in favor of the plaintiff, and I wasn't too disappointed. I thought, if I'd have been that jury, I probably would have voted against the doctor because he was so obnoxious. So that's a couple of examples. Other cases that I worked on, people might remember, is the the riots at the state penitentiary in the 1980s, I represented the architectural firm, I think they were from New York, at least I remember going to New York, who designed the control center, which is very involved in the riot and held up pretty well. And I don't remember this was due to my brilliant lawyering or the plaintiff's lawyer decided to dismiss them from the case, but either I got it in summary judgment or that didn't go very far. And I was only in the case long enough to see some of the documentation and the evidence and what a horrible tragedy that was and what people did to other people. And then another case that some people your age and my age might remember is the botulism case from Colonial Park Country Club in Clovis, New Mexico, and that involved a buffet that had been set up and people getting food from the buffet, and one of the food products had botulism, and it got probably spread to other food products in the process of the day, and several people got sick, and I think at least one or maybe two people died. So I spent literally weeks in Clovis doing depositions and discovery, and I don't remember who I represented. I was in the case for quite a while, but ultimately I got out in summary judgment, and I know the case ultimately went to trial. It turned out it was a 3-bean salad, as I recall. That was the source of the botulism. That was an interesting case.
Well, you obviously tried many, many, many cases during your career, and then as a judge, you sat as a judge in all of these litigation cases. Given all of your experience, what did you do to prepare for trial, aside from the typical issues of discovery and interviewing witnesses and talking to your client? What did you do specifically, maybe that nobody else did?
Well, I think probably I was one of the first lawyers to make use of a trial notebook. I'm not a slow learner, but I like to have things available to me so I can refresh my recollection, and so that was one of the things that I did that I don't remember other people doing. I had it prepared with the essential pleadings and outlines for all of the witnesses, including I would have outlines of the questions I wanted to ask the witness and a reference to where I could go to the deposition to impeach him if they didn't give me the answer that I thought I needed or that I wanted. But I would say if there was one thing that I did that resulted in a favorable ending is really preparation. When you're a defense lawyer, you don't get to pick and choose your cases. So plaintiff's lawyers don't always get to pick, but they can to some extent. And defense lawyer, you didn't get to do that. You if you're representing clients from an insurance company, you get whatever case they've got, and sometimes they were pretty ugly and difficult to defend. So you have to probably prepare a little bit more. I mean, being a plaintiff's lawyer is more like you're telling a story and you've lived with it, you live with these people, and it kind of has a flow to it. When you're a defense lawyer, you have to, just kind of poke holes in the case, and hopefully at the end of the trial you've poked enough holes or you've come up with some fatal flaw in the case that you can convince the jury that in spite of the horrible incident that happened or the injuries that your client deserves to have the manner of judgment in your client's favor. So I would say just preparation, and there's this old saying that success meets at the intersection of preparation and opportunity, and I think that's what I couldn't control the facts of the case. Other lawyers may be better lawyers than me, they may be smarter than me, but I always had the philosophy that nobody is going to out-prepare me. I'm going to be ready for this trial, and we'll see what happens.
There's always issues from the attorney's perspective of what do the judges like and don't like, And then what do juries like and don't like? Given your experience that we've discussed, how do you handle that question?
Well, judges want you to move on and don't want you to have a lot of repetition of the same thing from every witness. You know, and that's why, you know, you have pretrial orders and you have pretrial conferences, and you kind of narrow down the number of witnesses. Somebody really need 5 witnesses to testify about whatever the particular issue is, and so that's from the judge's perspective, and lawyers. I mean, the jurors. I think nowadays they like a lot of show and tell. I mean, back in the old days, most you would get would be an accident reconstruction expert who might be able to do a demonstration of some sort. Now, then later on with PowerPoints, you can do a lot more than you were able to do initially, and now there's so much more that lawyers are able to do with all the tools that are available to them. But I think jurors like to be educated, and I wouldn't say entertained, but they need to have things explained to them in a way that they understand, that hopefully the judge understands without having too much trouble. And some judges were more concerned about objections than others. Some judges have way too many bench conferences. Some don't have any, and I would generally tell the lawyers, look, you don't need to make a speaking objection. You just tell me what the objection is, the basis of it, and I think I have enough experience I can decide whether or not it's appropriate. But judges don't like lawyers making speaking objections in general, or arguing their case when it's not appropriate. But
which is one of the things most lawyers like to do.
Exactly. Yeah, and you have to figure out how to do that. And I can remember, and this happened only once that I can remember of, but I was trying a case with this fellow, and this was an accident case, and he was cross-examining, or he was examining a witness who was testifying to what he saw and what his vantage point was, and could he really testify about what he said he testified about. And I thought I did a brilliant job in cross-examining. And the judge starts rehabilitating him and asking him questions. And so I said, Judge, when he was finished, I said, could we take a recess? Something I'd like to talk to you about. And he said, okay. So we excused the jury. I said, Judge, I don't want to be disrespectful, but this plaintiff over here has a very fine lawyer representing him, and I don't think he needs your help, and I don't think it's fair to my client. And so I'd appreciate it if you could refrain from rehabilitating his witnesses. And, it was a pretty gutsy move on my part, but it worked. So, nobody ever did that to me, but that was the biggest challenge to me as a judge. I had to bite my tongue because I so wanted to say, "Oh, you idiot, why don't you ask this? Why don't you do that? Why are you doing that?" And you just sit there and smile, try not to have facial expressions that would give away how you feel about something. It's frustrating.
We've talked an awful lot about the legal side of your experience as a trial lawyer and as a judge and as a mediator. But I also know from my own personal experience that you were very active in the state bar. And I know we're sitting in a building that would not have been built but for your efforts. So can you talk to us about your activities in the state bar to include the construction of this building?
Okay, well, I don't think it would be fair to say I was responsible for the construction at the state bar. I did my part, and I did have a role to play in it. But to answer your question, I've been a bar junkie all my life. It started in law school. I was president of the Student Bar Association. When I came to New Mexico, I was president of the Young Lawyers Bar Association. And I was president of the Albuquerque Bar Association. And then I got the state bar involved in something called the Jackrabbit Bar Association, and I became chancellor, is what they called the president. It was a very interesting organization. I learned about it from an ABA conference that I went to. It was made up of the smaller bars in this part of the country, Utah and New Mexico and Idaho and South Dakota, North Dakota, where we could talk about issues that were more important to smaller bar associations than the big things that are talked about, like the ABA convention. And so they would always have their meetings in out-of-the-way places, and we'd have a good discussion. And I invited them when I was chancellor to, the Mountain Gods, and that was a lot of fun. And it's through bar activities that I thought I could make a contribution that was more than just representing an individual client. I wanted to do something that would help the profession or help the public. And one of the things that I was involved in when I think this is when I was Young Lawyers President, was the mock trial program for high schools, which is still in existence. And when I was president of the Albuquerque Bar, I brought these ideas with me from Chicago. We started the Outstanding Judge and Outstanding Lawyer of the Year. I don't remember what year it was, but I remember that Jerry Cole was the judge and Dick Ransom was the lawyer. And then Art Jaramillo and I worked with Dean Winograd at the law school to start what later became the Art Jaramillo Summer Law Clerk program, to give law students who might not otherwise have an opportunity to work for a big law firm to get that experience and maybe convince somebody to give them a shot. So those are some of the things that I did at other bar associations. At the state bar, I worked on a lot of committees and did things and worked my way up to the chairs on the Board of Bar Commissioners. I was on the Board of Bar Commissioners for 10 years, and during the time when I was working my way up the chairs, I may have been president-elect, and we were dealing with, do we want to build a bar center? Can we build a bar center? What do our members think about building a bar center? And we were also having issues at that time, some concern about whether we should be an integrated bar. Everybody has to be a member of the bar, whether they want to be or not, or whether it should be a voluntary bar. And there was actually a lawsuit that was filed involving that. Judge Burciaga was the judge in that case, and he ultimately ruled that it was okay to remain an integrated bar, but we'd have to disclose financial information for all of our members, so if they wanted to object to something, they could. And then building the bar center became very controversial also, and I remember talking in front of Albuquerque Bar Association and other bar associations about why that would be a good thing. And admittedly, I didn't always do a real good job, but I did my best. But we worked very hard with not just me, but all the members of the Board of Bar Commissioners to find a place. We thought about various places, and somebody came upon this vacant land, and we decided that rather than buy a building and try to remodel it or make it work, we would just build a building. We could design it the way we wanted to design it, and so that's what we did. Then the issue became, how are we going to pay for it? So by then, I'm pretty sure I was president or president-elect, and so if you remember Linda McDonald, who was executive director at the time, she and I traveled all over the state of New Mexico to visit with all the local bar associations and to visit individuals. You'll see around this building, there are buildings that are named after people, and that's from our talking to either if somebody was deceased, there, maybe a wife or a foundation or somebody like that, and then working with the larger firms, getting them to contribute money. And so by the time Linda and I finished this journey, I knew where every yogurt shop was in New Mexico. So that was one of my favorite things. If wherever we were going had a yogurt shop, we had to stop so I could get some yogurt before we went home. But it was a very interesting experience, and I don't know the ultimate number, but I'm sure it was hundreds of thousands of dollars that we raised, and I don't remember the specifics, but I'm sure we had to finance some of the construction. But I hope the building is paid for now, and although it was controversial then, I think everybody now is sort of taking it as a nice facility and very useful for our membership.
I think that's a given amongst the population of lawyers that I'm aware of, is that, and as we discussed before, I personally was against it. I was one of the people who thought that it was going to be a waste of money. I see your name on a
plaque out there, so I must have twisted your arm.
Look at you, twisted my arm more than once. But I think there is not just general agreement, and I would say universal agreement, that it was a great idea and that people are pleased and happy that we have this building and this State Bar Association as a way to help us and assist us in our practice of law.
Yeah, well, it's turned out to be a great facility. The concern now is they're running out of space. We were going to make it bigger and have it more on the second floor, but for whatever reason, we scaled it back to the size it is now. And you know, at the time, the hope was that we could bring other organizations like the Municipal Discipline Board and some of the other to have their offices here, and that never really worked out either. And it's probably just as well because the State Bar has managed to use up all the space with their own staff, and so.
Yeah, well, now they even have a printing facility in-house.
Right.
And
Well, they did. I think now maybe out off another location now because they've used that space for something else. But no, it's been a wonderful building and been very useful. And as a matter of fact, when I started doing private mediations, I was working out of my home. I didn't have an office, so I would rent the conference rooms here, like other mediators have done, and it was a very modest fee, and it was very, very, very helpful to me in that respect.
yeah. And you know, I was a chair several times of the Senior Lawyers Division, and our signature event is the Memorial Scholarship event that we hold here at the in the auditorium. And of course, when we have board meetings, we meet here at the State Bar facility. And in the absence of having this facility, it would have been very difficult to accomplish those kinds of things.
Right. Yes.
And the State Bar has been very, very helpful to us in terms of providing administrative assistance to our facility. You've done an awful lot in terms of private practice, public practice, and your State Bar activities. And I know that you've received some acclaim and some awards over the years. Now, I know personally from talking to you that you don't like talking about that, but I think that that's a legitimate part of your history. So I'm going to ask you about the awards that you have received and for what reasons.
Well, I received several contribution awards for things like working on the MCL committee and some of the early committees, like discussing things that involve the State Bar and its members and other organizations, like how do you relate to doctors and things like that. And so I would get little plaques that were contributing to something like that. But probably the award that I'm most fortunate to have received is in the turn of the century in 2000. I think the ABA came up with this idea of presenting what they called Century of Achievement Awards to people who were involved in bar activities, well-respected, outstanding members of the legal profession and community activities and so forth. And I was fortunate enough to receive one of those outstanding Century of Achievement Awards for the century, or for the decade from 1990 to 2000, which included the years that I was on some of the years I was on the Board of Bar Commissioners and the year I was president. And then later on I received the President's Award, which the president each year gets to select somebody that they think has been particularly helpful to them or to the bar, so I was honored to receive that. And I don't remember, it's enough.
In our discussion, in my reviewing your historical information, it seems as though you became president of any organization that you participated in. How do you explain that?
Well, I'll tell you my general philosophy about anything. If something is worth doing, it's worth doing well. So when I would get involved with something, I was going to give it my best, and I wanted to participate in a meaningful way, not just be somebody who sits around a table and listens to what other people have to say. And it's probably sort of my nature that I'd rather be a leader than a follower. So that's maybe explained it. I don't know.
Yeah, that does explain it. There's an award that's given by the State Bar, and your pictures are in this building for receiving that award, the Rail Award.
The Rail Circle of Honor, I can give you the history behind that. This goes back to when I was trying to raise money to build the State Bar building. In addition to successful lawyers like you, I talked to a lot of individual lawyers trying to get them to contribute. And one of the ones I talked to was Jerry Rail. And I knew Jerry's father, Joe, from having cases with him, and he was the one I interviewed when I had an opportunity to work for the model firm. And so I said, Jerry, come on, give me some money. He says, well, I'll do it if I can figure out some way to honor my dad. Let me talk to my dad. So we talked to his dad, and his dad was really opposed to just putting his name up on a conference room. He said, if you can figure out some way to honor trial lawyers, because that's what he was, then it's okay. So I don't know whether it's Jerry or Jerry and his dad came up with this idea of a Rail Circle of Honor to honor outstanding trial lawyers, and that's why those plaques are out there in the entryway, and Joe's bust is in one of the alcoves out there. And so that's the genesis of that, and I was fortunate enough to be one of the people who were asked to be a member of that, and I'm one of the people who helped select other people to be members. And two other things that, just so we can say we covered them, that I'm proud of is my last year on the bench, I was selected by the American Board of Trial Advocates as Judge of the Year. So that was a nice way to end my judicial career. And then when it came to doing mediations, and this was after I had resigned, but there's an organization called the National Academy of Distinguished Neutrals, which has offices in New York, and they have a program where they try to get mediators from around the country, and then they do some publications to help the mediators get work, and they have conventions every other year, and they have a referral process that if you need a mediator in New York or New Mexico, you can go on their website and it'll show where the mediators are. So I was one of the first 5 mediators in the state of New Mexico to be asked to be a member of the National Academy of Distinguished Neutrals. So that's an award that I'm also proud of.
Didn't you also do some activities regarding the State Ethics Committee?
I still am. In dealing with those kinds of voluntary issues, I've been a hearing officer for the Medical Disciplinary Board for many years. And more recently, as you may recall, the legislature for years was dealing with trying to develop a statute that deals with ethics as it relates to public employees, public officials, and so they created the State Ethics Commission. And State Ethics Commission needs hearing officers to hear these cases, and I was one of the first 2, and I think it requires you to be a retired judge. I was one of the first 2 judges, and I think there's still only 2 or 3 that deal with these cases. They're very interesting cases, but like most legislation, the legislation wasn't perfect, so there's still some things that I think need to be fine-tuned, but I've handled 4 or 5 of those cases. They're very interesting. They involve interesting people and things that you read about in the newspaper, and you get to dig into seeing the underbelly of the case, and that's been interesting. I'm still doing that.
One of the discussions we had before we went on live on tape today, was, given all that you've talked about and all that you've done, how did you get it all done?
You know, I look back now and think about that, and I get myself exhausted. I don't know. I don't know. I guess the answer was I was younger and more energetic than I am now, because in addition to, you know, legal work, and I was one of those lawyers that generally worked on Saturdays and Sundays, at least part of Saturdays and Sundays. I was involved in other activities, primarily sports-related activities, and in my mid-40s I started playing golf, so I wanted to have a little time to do that. But I just made it happen, and I look back now and how did that? How did I do that? I coached Little League, Little League with Ken Harrigan, who had a son who was on a Little League team for a couple years, and then for 25 years I officiated high school basketball, high school football, and college football. In addition to officiating the games, which could be Tuesday or Thursday night for basketball, or Friday or Saturday for football, you had to go to meetings every Monday night and you know, deal with preparation and educating yourself and the rules and issues that come up. But when I look back at it, I wouldn't change a thing, because I made lifelong friends doing that, and it's a wonderful experience. I mean, I've like being involved in the Bar Association, I got to meet lawyers from all over the state. Well, being involved in officiating, I got to meet coaches and high school administrators from all over the state. I mean, I officiated basketball tournaments from Raton to Reserve. I officiated football games all over the state, and was fortunate enough to officiate several state championship games and all-star games in the Pit and in the Pan Am Center in New Mexico. And then in college, this was really a wonderful experience for me. I was on a college crew that we officiated in the Rocky Mountain Conference. So it would be Highlands is the closest, but he'd go all the way to Alamosa, Durango, Gunnison, which was a trip from hell, you can imagine, and eastern, western Panhandle State. And we would meet at 5 o'clock in the morning, have breakfast at Denny's or somewhere, get into the van, and we would drive to wherever the game was, officiate the game, drive back, all in one day. Unless we were going to Gunnison, we would stay overnight, but generally it was a one-day trip. And my crew, we had an insurance person, we had an electrician, we had a security official from Alamosa, high school principal, dentist, and myself. I mean, it's a good cross-section of people. We're all still friends to this day. Unfortunately, our crew was good enough that we were selected to officiate several playoff games in Texas and in California for the Division II, which it's a level below, like where the Lobos and the Aggies are, football playoff games. So it was just a wonderful experience, and I met so many wonderful people, and one of them is still officiating. He's now in the NFL. He was a referee in one of the games that were played on Sunday, and he officiated a national championship game for Division I several years ago, and he's a good friend of mine. So it was an interesting experience.
Now, looking back over our discussion today, in terms of all the activities that you've had, it's my understanding that you're quite a good golfer.
Well, we should probably put that in the past tense. When I was younger and played more, I was able to maintain a single-digit handicap, but that was when I primarily played at Upper Country Club and some of the local clubs on the Indian land, casinos. But several years ago, I joined what's now called the Canyon Club. It used to be Four Hills, much more difficult course, and I'm not nearly as good a golfer as I used to be, so my handicap is now about double what it used to be. But I still enjoy playing, but I've got a gimpy back, so I can't really play more than once or twice a week, and I can't very often play 2 days in a row. But I still do play, and that also has been what I've played some of the most well-known courses in the world, in the United States and in Scotland, and going on trips with guys, and that's a lot of fun.
What are some of your favorite golf courses?
Well, I'll start with the United States. Pebble Beach, I played that several times. And working your way across the country, I would say Whistling Strait's a very difficult case up in Wisconsin near the Illinois border. I've been blessed. Well, I played Pinehurst number 2 and the other Pinehurst courses. I've been blessed to have been able to play Augusta National, which is where the Masters is played. Not very many people get that opportunity, so I was fortunate to do that. And the Ocean Course in Kiowa Island in South Carolina, North Carolina, I can't remember. But my favorites, and I've played quite a few of the courses in Mexico, but my favorites are, I would say, in Scotland, where I played the old course at St. Andrews and Carnoustie and Muirfield and Donald Trump's course now. I forget what it was called then. He owns the course now, and Troon North. And that's just a lot of fun. And in the United States, there's a course that are similar to the Scottish courses at a place called Bandon Dunes along the coast of Oregon, which is horrible weather like you experience in Scotland. And again, I was, young enough and stupid enough that I would play golf no matter what the weather was like. But I don't do that anymore either. It's got to be 50 degrees and sunny and no wind, or I'm not playing.
Looking back over your career, mostly in the legal community, how do you think, or how would you identify whether the legal community has changed, and if so, how it's changed?
I always say the most significant change is in the way we communicate with each other. Back in the old days, when you and I were active and had cases against each other, there was some issue. You would write me a letter. Tell me, this is my concern. How do you want to deal with this? And I would get your letter and I would read it, and maybe the next day or 2 days later I'd write the letter, and if I didn't like my response, I would redo it and send it to you. Or more likely, I would call you on the phone and say, let's just talk about this, let's see if we can resolve this. And now, primarily because of text messaging and emails, lawyers send out these ugly emails, and they don't get a response in 15 minutes, they're upset. They don't get a response in 1 day, they'll file a motion. It's just a deterioration in the communication. And I have on occasion invited lawyers to go to lunch with each other and talk about something other than the practice of law or the cases that you have, and that's sort of a way to try to get things resolved. But I would say that's the biggest difference. And there was a time when there was a lot of Rambo lawyering and really kind of aggressive lawyering. I think, and maybe it's because I haven't been as involved. I'm not sure if that's as bad as it was at one point. But I would say the basic difference is communication, and I feel so sorry for the lawyers these days when they're in trial, because I think of when I'm in trial, I get up, I go down to chambers, I may have something we need to talk about before the trial starts, and I just sit there all day and I listen to the evidence, and I have lunch, and then at 5 o'clock I go home, and I may have a glass of wine and have dinner and read a book or watch TV and go to bed. Well, here's the trial lawyer. The trial lawyer goes home at 5 o'clock, goes to their office. He's got a half dozen emails that need immediate response, and maybe some text messages, and it goes through their mail. Then they've got to figure out what they need to do to get ready for the next day, and they may have to take stuff home with them so they don't get to spend much time with their family and their kids. And they stay up late getting ready and get up early the next morning and do it all over again. So I can tell you it's much better being a judge than a lawyer when it comes to being in a trial.
There's been a lot of focus over the last maybe 5 to 10 years on professionalism and ethics. And what are your thoughts regarding why that became such an important issue? And how has that issue been dealt with by the profession?
Well, I think it became an issue because the lawyers themselves decided it was an issue. You know, we're one of the few professions that police ourselves with the disciplinary board and some of the other ways that we try to do that. So, and again, I think it involves a lack of communication and just a lack of, why are you a lawyer? What are you trying to achieve? I mean most of us, I hope, became lawyer because you wanted to try to do good things and to help people. But unfortunately, I think some people went to law school because they wanted to make a lot of money. And there's a big difference when you analyze the starting point and the objective, and I think that had something to do with
it. We've talked about so many different kinds of things, and I want to make sure that I haven't missed something that's important to you. Is there anything else that you think of right now that you'd like to share with us, either regarding your personal life, your life as a trial lawyer, your life as a judge, your life as a mediator?
You missed the most important thing.
Okay.
My wife. As you know, her name is Smokey, which
right.
is an unusual name, and I can explain that to you if you'd like. But because I was so involved in practicing law and doing other activities, I was not successful in my first 2 marriages, and I'll take my share of the blame. But I was blessed, and I really, truly believe that somebody else had something to do with this, to meet my current wife, Smokey. She had been divorced recently, and I had been divorced at about the same time. And she had no intention of getting married again, and nor did I. I'd built a new house, and I was living by myself and my dog, and I was fine. But she belonged to I had a group of friends that would meet for Monday night football games. They would go to different people's houses every week, and they'll all get together. And Smokey's mother was one of the people who would come to to these football games. And at some point, and I'm not sure why, how this happened, but apparently Smokey's mother announced to the rest of the folks that Smokey's ready to start dating now if anybody knows anybody. And Smokey was obviously embarrassed about that, but nevertheless, one of the people who was at that meeting was a lawyer, a lady lawyer that I knew, and I had seen her since I was divorced, or while I was going through divorce, so she knew I was either divorced or getting a divorce. So she thought of me for some reason. And so she called my law clerk and asked my law clerk, this is the story I heard from my law clerk, do you know if Judge Torgerson's dating anyone? And of course, my law clerk said, well, I don't know, because I didn't share that sort of information with my law clerk, but I wasn't. And so she said, well, I've got somebody I wanted to meet. So she said, okay, well, talk to him. So she talked to me, and she described Smokey to me, and said, would you like to meet? I said, yeah, sure. So give me your name and her phone number, and I'll give her a call. So she says her name is Smokey, gives me this phone number. So Smokey is obviously a nickname that her friends called her, and I'm not sure if that'd be appropriate for me to call her. Do you know what her name is? She said, no, I don't, but I'll find out and call you back. She called me back and said her name is Cheryl. So, that night or sometime shortly thereafter, I called Smokey, Cheryl, and she answered the phone, and she said hello, and I said, Cheryl? And I just had this feeling that this phone is on its way back to the hook, and I said, Smokey! She said, oh, yes, who is this? So I explained who I was, and I think as it turned out, this lady had maybe already mentioned that she'd talked to me, and she knew that I was a federal judge, so she didn't immediately just say, I'm not interested because I don't know who you are and whether I should be talking to you. So, but we talked. We agreed to have a blind date. Now, this is the first blind date in my life, and it turned out it was the first blind date in her life. So we agreed to meet at the Flying Star in Montebo, and it was December 3rd, and it must have been a nice day because I've been playing golf that day, but I agreed to meet Smokey, and we met at the Flying Star, and it turned out she was going to church services on Saturday night, and this was a Saturday, and it was also the day before her birthday, which I didn't learn until later, but so she, had wanted to have a quick meal and go to the church service. So we had about the same sort of meal that you and I did, is something real items. It was the most inexpensive date I'd ever been on. But we got along well, and so when I got home, I called her and I said, I enjoyed meeting you, and I'd like to get together with you again. And so we met for lunch that next week. And long story short, we started dating, and but she was very cautious. For the first several months, she would meet me wherever we were going to a movie or going to dinner, and wouldn't tell me where she lived. And finally, I guess, after she realized I was a federal judge and had passed an FBI clearance, that it was probably okay for me to pick her up at the house. So I did, and then we started dating in earnest, and I met her two beautiful, wonderful daughters, and got their approval, and 9 months later, we got married, and now I'm, so I didn't have any children of my own, which is my biggest regret in life, obviously, and I haven't been a father. But I've been able to sort of be a father to these ladies because they don't have a relationship with their father, so that's been nice. And we now have 3 grandchildren, and the girls live in LA, which is unfortunate. We have to go to LA. We want to visit them, and I'm not a big fan of going to LA, but it's been a blessing, real blessing to me. You'll have to ask them if they think I'm a blessing to them. But I can only speak for myself. But I want to tell you a funny story about Smokey, because it was a nickname. When she was born, apparently her eyes were sort of gray, and her dad said they're kind of a smoky color, and so Smokey kind of stuck. So throughout her life, she was known as Smokey. So when we started dating and found out she had gotten divorced, and she regretted that she still had the name of her ex-husband, I said, well, you can change that. She said, I can? I said, yeah. I said, well, can I change my first name too? I said, yeah. So I did a name change petition and filed it, and you have to publish it and get a hearing, and the judge has to approve it. And so I went through that process, and the case got assigned to Linda Vanzi. So Smokey and I are going to see the judge to get a hearing date for her to approve the name change. And so we're talking to Judge Vanzi, and she says, how about 1 o'clock on, I don't remember the date, 1 o'clock at such a date. And I said, that's fine. And Smokey said, that's fine, but she had kind of a weird look on her face. And so when we were leaving, I said, what was that all about? Why did you have that weird look on your face? She said, that's the exact hour and date that I got married to my ex-husband. So it was one of those weird coincidences. So now her name is illegally Smokey Torgerson.
Wonderful.
So that's my story.
All right. Any words of wisdom that you can give to young lawyers these days?
Well, yes. Take the profession seriously, but don't take it too seriously. And don't take yourself too seriously. And above all, don't let it interfere with your family. That's the one piece of advice I would give people. It's family first, and then your profession. And you can place the country and God and religion wherever you want, but whatever you do, try to be a good family person.
We talked a little while back. I had asked you if there was anything else that you wanted to share. And you talked about the relationship with your wife, Smokey, in great deal and very positively, to your credit. We haven't talked about the law firm that you helped to start. Do you want to share with us how that happened and what happened once the law firm got going?
Yes, thank you very much for bringing that up because that has been a very important part of my life. I've been in the legal business for over 50 years, and 25 years of that time was when I was with my old law firm. I'll give you the brief history. I got together with Rand Miller in September of 1978, and Bill Stratford joined us in January of 1979, so that's probably really the beginning of the law firm, as most people knew it as Miller, Stratford, and Torgerson. Unfortunately, what a lot of people may not know, at one point, at about that same time, we had a fourth member, a fellow named Ken Brandt, who joined us from the Rohde firm. And unfortunately, within the first 2 years, I think, I can't remember the exact date, but he'd been working real hard, so we wanted to send him and his family on a trip to Hawaii. And unfortunately, he drowned while he was in Hawaii on that trip.
I remember that.
And he had a wife and a young daughter and a toddler who may have been 2 years old. So that was one of the sad things that happened early on. But we proceeded, and there was always a resistance, like I think there are with many firms, that we didn't want to get any bigger. We want to be a big firm. That wasn't our goal. We wanted to be a good law firm. But as things progressed, we were asked, by people to do work for them, and it just became obvious that if we were going to take on this work, we had to have some additional people. So we were very deliberate because we didn't just want to get bigger. If we're going to get bigger, we wanted to get better. So, at least from my perspective, I always wanted to make sure that if we were going to hire someone, that was going to make us a better firm. And fortunately, we were able to hire some incredible lawyers over the years, and the practice was, I think, successful by most people's standards. We were never the biggest firm in the state, but I think at one point we were the third biggest firm. When I went on the bench in 2003, we had 55 lawyers in offices in Albuquerque, Santa Fe, Farmington, and Las Cruces. The firm has since downsized, like a lot of firms have, but it was a wonderful experience. I think I've mentioned before, I had an opportunity to work with some great mentors when I was a young lawyer. I had an opportunity to work with great lawyers and as partners, and had a wonderful experience with associates. And probably what I didn't mention, which I always tried to do, and this is an example where I forgot to mention the staff and how important staff is to a lawyer's success. You and I know that the trial lawyer, the lead lawyer, gets the credit and the blame if something goes wrong. But the people who really do a lot of the work behind the scenes are an associate as a second chair lawyer, or more importantly, the staff, the legal assistants, I guess now people call them administrative assistants. When I was in private practice, they were secretaries, and I had the privilege of working with some wonderful legal assistants. And I'm not going to mention any attorneys by name or any staff by name, except I'll make one exception, and that was my secretary, who became my legal assistant when I became a judge. Her name is Carolyn Saxon. She worked for me for, I think, over 25 years, and God bless her. She deserves an award just for that. But
I remember her because if I wanted to get to you, I had to go through her.
We had a great relationship, and I can honestly say in the 25 years we worked together, I never had anybody complain about Carolyn.
That was true. I want to go back. That's wonderful that you made that acknowledgement to the people who supported you. They often get lost in the mix, and sometimes we give them credit, and sometimes we forget to give them credit.
Exactly.
But going back to the beginning, when you and Rand Miller decided to get together, What was the chemistry between the two of you? Why did the two of you think that you had a winning idea for the law firm?
Well, probably have to ask Rand that question. I viewed it as an opportunity to start my own firm. I mean, I went from one firm to a smaller firm when I could have joined a large firm, but I wanted to be more involved in having something to say about what was going on and what type of practice we had. And I didn't really know Rand that well. I knew him because we had a couple of cases in common, and I think if the truth were known, I was a second choice because he really wanted to get together with somebody else who originally had said he would, and then he backed out because his firm put the pressure on him. So I was second choice, but we got along. We got along fine, and I guess I should tell you a story about that because we're both kind of A-type personalities, I guess you would say. We're want to be lead lawyers, not second chair lawyers. For that reason, we only tried one case together in all the years we were associated, and it was a non-jury trial. I won't mention the name of the judge. He was a very interesting character who often reached the right result, but for reasons that were unique to him and not what you might.
I think I know who you're talking about.
Might expect. So Rand and I were trying this. It was a non-jury trial with this particular judge, and we do the trial. He takes a couple of witnesses, I take a couple of witnesses, and we get to the closing, and Rand is giving the closing argument, and I'm sitting here, and Rand is at the podium, and then the judge is up at the bench, and this particular judge has a way of asking questions. If you don't pay attention, he could be throwing you a curveball. So he asks Rand a question that basically called for a yes or no answer, and Rand said yes, and I'm sitting in my chair going, and the judge said, "Well, your co-counsel doesn't agree with you." And to Rand's credit, he said, "Well, then he can do the rebuttal." So that was our only experience, and I never did try a case with Bill Stratford. I tried cases with just about everybody else in the firm, but Bill and I never tried a case together. But we've always got along together, and are still best of friends to this day.
You talked about being a mentor and being a teacher. Who were your mentors?
Well, I think I mentioned the first person I worked for in Chicago was a fairly young lawyer at the time. He had created a firm just a year or two before I went to work for them. He was University of Michigan graduate, very smart, very detailed, and so he was my first mentor in terms of evaluating a case and putting things together and getting to the guts of the case and then how to present it to your client. And then when I came to Albuquerque, Juan Burciaga, I think I mentioned, was obviously a mentor to me. And then when I joined, it was then Schaefer, Budd, Thornton, and Jones, as I recall. Gil Schaefer and Paul Budd had a lot of trial experience. Paul and I tried a couple of cases together early on, and one including we represented Ford Motor Company up in Tierra Maria. I think I may have mentioned that, where we fortunately got a good result. But those were some of the people, and then other people in the firm that I was associated with. I mean, you don't have to be older or more experienced necessarily to be a mentor for somebody. You can be a mentor in other things, aspects of your life. And so I learned a lot of things from a lot of different people, and probably could have learned more.
But you were also a teacher to the people who you worked with and the people who worked under you.
Well, yeah, I think probably more so than anybody else in the firm, I sort of worked with associates, and I would always have somebody else helping me on occasion, generally, and give them assignments, and then much to their chagrin, I would evaluate their assignments, and I had a bad reputation for my red pen because I would ask them to draft a motion or something, and I would go over it and make changes and add things, and may even put a grade on it, and so I don't know how popular I was about that. I think I was the subject of some jokes, and Judy Nakamura, who you know, worked for us, and she tells the story. I don't have enough recollection to deny it, so I'm going to assume it's true. But she tells the story that she drafted a motion for me, and I made some changes on it, and she says she took it back. She made those exact changes, nothing else. Gave it back to me, and I did the same thing all over again. And that sounds like something I might do. But some people don't like to delegate. They want to hang on to things themselves. It's the opposite. I delegated as much as I could because it was helpful to me, but it was a good learning experience for the other people. And some people are lead attorneys. Other people are second chair attorneys. Other people are appellate attorneys. Not everybody can be the lead attorney in a trial practice, and the other roles are equally important. So my philosophy was everyone should, try to be the best lawyer you can be. You don't have to be the best lawyer, just be the best lawyer you can be. I never considered myself the best lawyer in any situation. That's up to others to judge. But I encourage people to challenge themselves, push themselves. Don't be afraid to ask for help, and just be the best lawyer you can be.
Now, as one of the things that I remember about you practicing, having cases against you, was that you were a very agreeable defense lawyer. And discovery is a major issue, particularly these days. And my memory was that you were very fair and very reasonable when it came to discovery, and very tough at trial. So how do you explain those differences?
Well, thank you. I take that as a compliment, and I appreciate that. Well, I mean, the rules are the rules. If you follow the rules, that's what should happen. I mean, you have a duty to disclose and produce and to be cooperate, not file frivolous motions and those sorts of things. And I hope I never did that. But I always thought it was better to try to work with somebody than fight with somebody, because it doesn't usually get you anywhere. It costs your client money, and in all likelihood, the result's going to be the same whether you fight about it or whether you agree to it up front. And so I tried to do that. And when you're in a profession like this, the most important thing is your reputation. And I always wanted to get to the point where I thought people thought they could trust me and they could believe me, not just people that I worked with, but opposing counsel and judges, because that can go a long way. And as you pointed out, that doesn't mean that you have to roll over at trial and be the same person. You have an obligation at that time to represent your client to the best of your ability, and you have an obligation to be a zealous advocate, but not a overly zealous advocate, and protecting your client and doing what's in the best interest. But there was no reason to fight just for the sake of fighting. If something was appropriate, then do it.
I think you touched on something that strikes a nerve with me in terms of the way I was forced to interact with a lot of attorneys. There's a difference between being a zealot and conducting zealous appreciation for the rules and the facts of the case. And I think that that's an important distinction.
Yeah, you and I went to this period where you probably heard about the Rambo lawyers.
Right.
And I think what happened to a large extent, not so much in New Mexico, but in bigger cities, bigger firms, it became all litigation became a practice, a motion practice, a way to fight and to make money, and then you would settle the case. And that wasn't the way I was brought up. I don't think that's the way you were brought up, and unfortunately that did happen. I mean, people were being unnecessarily
Zealous
for no good reason other than maybe that was their personality. But to me, it just was not the way that I wanted to be remembered, and I didn't want our firm to have that reputation.
You talked about being a mentor and a teacher. I also remember that you did several CLEs, continuing legal education programs. Can you talk about that a little bit?
Yes, I did. I never really wanted to be a teacher in the sense of a professor in the classroom, but I felt comfortable sharing my experience and what I could about the things that I was limited to. So I've done dozens of continuing education programs for the State Bar, the Albuquerque Bar, the trial lawyers, the Defense Lawyers Association, and national associations. And I was a judge. I spoke at the Department of Justice Advocacy Center, the Federal Judicial Center. So I like doing those sorts of things that would focus on trial practice, what judges like, what judges don't like, mediation, professionalism. But I never really wanted to be a full-time professor, but I enjoyed doing that. Sometimes I would do the program myself, sometimes I would be on a panel, sometimes I'd be a moderator. But and before we got all these organizations that now inundate you with programs that you can pay for many years, the State Bar would call me in November and say, "We need another CLE by the end of the year. Can you help us out?" So I would call on some of my friends or judges, and we'd put a program together at the last minute. So I enjoyed doing that, but it's not something I'd want to do on a full-time basis.
I noticed you said in your last response that you also did programs for the trial lawyers, the plaintiffs' bar. What was that like, walking into a room with 150 plaintiffs' attorneys?
It was fine. I was actually, I don't know if it was a paying, I think I was at the time as a paying member of the trial lawyers. That's fine. I even spoke at the American Trial Lawyers Association changed their name. I can't remember what it's called now, but I even spoke at one of their meetings in Denver shortly. I think it was after I retired, but I'm comfortable in being in the den of the enemy. But their trial lawyers are fine. They're some of my best friends are trial lawyers. Many of my former partners left the firm to go become trial lawyers and were very successful.
Well, how about some of your former partners that went on to become judges? There seems to be a number of them.
That's one of the things that I'm most proud of in terms of our firm. I'm quite sure I could say that our firm produced more judges than any other firm in the state of New Mexico. My last count, if I'm correct, there were 8 lawyers, including myself, who went on to become judges. One of is in the 10th Circuit Court of Appeals. I mentioned Judy Nakamura. I remember helping her campaign for her first judge position. She went from Metropolitan Court to District Court to Supreme Court, and ultimately was Chief Justice of the Supreme Court. So I'm very proud of her. Others are Judge Shepard, Judge Ramzik, and Manny Arrieta in Las Cruces. And in addition to myself, Steve Vidmar was a U.S. Magistrate Judge. Seth Bingham was a part-time U.S. Magistrate Judge. So I think I've mentioned everybody. And
the only one that you didn't mention by name was Harris Hart.
I stand corrected. I should have mentioned his name.
Because if he watches this...
I wasn't going to mention any names, but Harris and I are dear friends. I've watched his kids grow up, and we've been friends for years. And I will say this, as I said before, I hate to mention some people, and not because I'm always going to forget somebody else that won't offend anybody, but I think I can safely say that Harris Hart is the smartest lawyer I ever worked with, and extremely good at analyzing, writing, and he's done a great job in the 10th Circuit. I think he's very well respected, and we're very good friends. We've spent a lot of time together.
Yeah, he's a good man.
He is a good man.
We're talking about your teaching and how you mentored lawyers in your firm, and the CLEs that you did both as an attorney and a judge. Fears and pet peeves.
Well, I give you some of these may seem silly, but I'll give you a pet peeve first of all. And this is when I was in private practice, and this goes back a ways. I would get a phone call, and our receptionist put the call through to me, and there'd be usually a lady on the phone say, Mr. Torgerson, yes, could you hold a minute? Mr. Revo wants to talk to you. I would very politely say, no, I can't hold it. When Mr. Revo has time to call me, I ask him to call me back. That was a pet peeve of mine. And one of my partners did that, and I criticized him for that also. That was a pet peeve. And then when I was on the bench, my pet peeve was when somebody would try to blame somebody else in their office for something that happened. And knew that they're the lead lawyer of the team. They'd say, oh, well, my associate failed to remind me of that, or my administrative assistant didn't do this. And I was, it's your name on this pleading here. You're the lead counsel. And it's your responsibility. And I don't think it's fair for you to criticize somebody else. If they did something wrong, then maybe you didn't teach them appropriately, or give them the right advice, or follow up to make sure they were doing things appropriately.
I'm sure they were happy to hear that.
That was my pet peeve when I was on the bench. In terms of fears, my greatest fear when I was on the bench, we did detention hearings as part of my job as U.S. magistrate judge on a daily basis, and we had the same rules basically now that the state court judges have in terms of what you to consider, and we would get reports from pretrial services and their evaluation, and then we'd have to make a decision about whether or not we could release somebody or whether they'd have to be detained. And my biggest fear was that I would release somebody and they'd go out and do something else horrible, which unfortunately has happened. It never happened to me, thank goodness, but it has happened, and that was my biggest fear as a judge.
How about it as an attorney?
Well, I didn't really have any fears in terms of, going to trial or doing my daily job. I'm most embarrassed to mention this, but my biggest fear was that I'd be making a closing argument, and I'd look down, and my zipper would be open. That was my biggest fear. Something silly like that. I mean, so I didn't ever fear the courtroom, or I did the best I could with whatever case I had.
Let me rephrase that question. What was your biggest worry as a trial lawyer?
Well, the biggest worry is you never stop worrying. That's the problem for me. Some people can go to bed, go to sleep, wake up when the alarm goes off. When I was in trial, I'd go to bed, and as long as I was asleep, I was okay. But if I woke up, whether it's 2 o'clock or 7 o'clock, I start thinking about the case, and then I couldn't turn it off. And that's another problem with, I think, that being a trial lawyer is how do you turn that off? And that's why I mentioned, I think, officiating, how that was helpful for me. I mean, people would say, why are you officiating? You already have a stressful job as a lawyer. Why would you want to be an official? And in reality, it was a way for me to relax and forget about my cases, because I'd have to focus on what was going on in the game and make sure that things were being done appropriately. And if somebody was a jerk, if a football coach said somebody did something, I'd just throw a flag and give a 15-yard penalty, and we'd move on. If the basketball coach said something that I didn't like, we'd just give him a tee, and then we'd move on. And so it was a way for me to relax. And so in addition to making a lot of friends, it was really a way for me to step away from the practice of law and focus on something else.
You bring up something very interesting about the practice of law. Oftentimes you do something and you don't know one way or the other whether it influenced the eventual outcome of the case, because you're making 100, 200 decisions a day, both internally and externally. And by officiating, you see something, you know what the rule is, you make a call, and it's over.
And it's over, exactly right. So I can relate to that in this context. I've tried to give you some idea of how stressful being the trial lawyer can be. And it's even more so now, because now, if you're a trial lawyer, you go to trial in the morning, you start at 8:30 or 9, whatever time the judge wants you there. You go through trial, you take a lunch break, you're probably interviewing a witness, looking at your notes, maybe eating a sandwich, and you stay there the afternoon. Then when the trial is over, you go back to your office. Instead of just having mail to look at, now you've got text messages, you've got emails, you've got mail, and you've got to figure out, do I have time to respond to that? Then you got to pack your briefcase and go home, hopefully spend some time with your family and have dinner, and then you work until 9, 10, 11 o'clock at night, getting ready for the next morning, and it goes on for the entire trial. That's very stressful. But when you're a judge, you show up at whatever time you tell everybody else to show up, and you listen to what they have to say. If there's something they want to talk about before you start, and you make a ruling, and you sit there and you make rulings so the case goes on, and you have lunch, and you either go back to your chambers and relax, or you might go get lunch somewhere, come back, you do the same thing in the afternoon. And then when you go home at night, you have a nice leisurely dinner. You may have a glass of wine, and you read a book, or watch TV, or spend time with your family. It's totally different, and that's the nice thing about being a judge, or being a mediator for that matter. You work on something, and then it's over. You don't have to live with it. When you're a trial lawyer, some of these cases can drag on for years, and you just can't stop thinking about them. At least I couldn't. Maybe some other people could do that better than me, but that was a problem that I had.
One of the things that you talked about was being the best lawyer that you can be. I'm not sure that you covered it all in terms of your thinking. So if somebody were to come up to you and say, Judge Torgerson, I just finished law school. I'm opening up my own practice. I want to be a sole practitioner, and I want to be the best lawyer that I could be. What advice would you give that person?
I would say, get a friend who has some experience. Or now the State Bar has so many mentor kind of programs and things available that weren't available before. To me, it would be terrifying starting your practice on your own. I mean, I started mediation practice on my own after nearly 40 years of experience, so that was easier than being right out of law school. But so I would say, don't be afraid to ask for help and run things. And I think defense lawyers are probably not very likely to share something or talk to somebody at another defense firm. What do you think about X, Y, or Z? Because that may not be appropriate. But I have the sense from talking to plaintiffs' lawyers that they'll bounce things off of other plaintiffs' lawyers who are friends of theirs. And so I think if you're in private practice, that's fine, but try to find a mentor. And it doesn't have to be somebody who's practiced. It could be an old geezer like me, or just somebody that, can you spend an hour or two with me once a week or once a month and help me through some of this problems that I might encounter in setting up my own practice. And so I would encourage people to take advantage of what the State Bar has to offer, but also don't be afraid to ask for help from somebody who's been doing it a while.
There's a lot going on these days about the work-personal life balance. And also kind of feeding into that is the issue of a person's moral compass. How did you look at those things, and when you were in a teaching or a mentor role, what did you say to people?
Well, follow your moral compass and be ethical, be professional, because there's the old saying, especially particularly not just with other lawyers, but with the court. There's the old saying that you only get one chance to make a good first impression, and if you make a bad first impression, particularly with the judge, that's not good, because then you have to overcome that. And really, every time you go to see a judge or you're dealing with a lawyer, if you are prepared, if you are professional, you're building up your credibility bank with that lawyer, that judge, that person. And that ultimately leads, as I said, to them being able to believe you when you tell them something, to trust you when you say you'll do this or you won't do that. So I think that's very important. And above all, keep in mind that your reputation is a whole lot more important than your won-loss record. So that's a guiding phrase that I would suggest everybody keep in mind.
There was something that you touched on, and I just kind of lost it. I'll be able to get back to it. You are considered to be a bar junkie. And we better describe that word before we go any further.
Well, I'm probably an ex-bar junkie now, but I always, going back to, I was president of the Student Bar Association when I was in law school, and then I've always been involved in bar association activities, and primarily because I thought that was a better way to reach more people and help more people than trying to do it on an individual basis. So I was president of the Albuquerque Bar, the State Bar of New Mexico, the New Mexico Defense Lawyers Association, and the Young Lawyers Association. I chanced the Jackrabbit Bar Association, but something I got the bar involved in, and involved states of similar size to New Mexico. I was a delegate to the ABA House of Delegates as a representative for the New Mexico State Bar. When I was in the bench, I was a 10th Circuit director to the U.S. Magistrate Judges Association. Just a way to get involved with the profession and hopefully help get things done. And it's a good way to meet people and to make lifelong friends. And if you work at it and do the right things, you can get things accomplished that will affect other people maybe for the rest of your life.
Now, it occurs to me as you're talking about these various different organizations, is that you rose to the top in almost all of those organizations. So what is it that drives you to want to be at the head of the organization?
Well, why wouldn't you want to be? I mean, I always consider myself, I tried to be a leader rather than a follower, and persisted, and wanted to, as I said, the goal was not necessarily for me, but the goal to try to work with these organizations to do things that were going to help the profession, and in some instances, the public, and how it relates to the profession.
Now, you mentioned wanting to be a leader. We're in this building and taking your oral history at the State Bar. Now, we didn't have a State Bar when I came to New Mexico, but you were very influential in terms of generating the idea of a State Bar and a State Bar building and helping it rise out of the ground to be what it is today. So would you talk about that?
Well, okay, a little bit, but I think we had a bar when you and I came here, but we didn't have a State Bar building. We actually did have another building over associated with next to the law school, and that got subsumed by another organization that I think I need to go into how that happened or why that happened. But I shouldn't get credit for wanting to have a State Bar building. That was in process and was being advocated by other presidents before me who were on the Board of Bar Commissioners at the same time I was, but I happened to be president when we made the decision to build the building, and then we needed to fundraise. So I was very involved in the fundraising, and I became the spokesman, sometimes not very eloquently or effectively, in trying to encourage people to support the bar and to support the building of a State Bar building. And fortunately, I think we may have talked about that a little bit earlier, but fortunately, the State Bar survived as an organization, and we were ultimately able to build this very fine building thanks to the support and contribution of lawyers like you.
Well, it certainly turned out to be an excellent idea
It did, and I can't take credit for the original idea. I only take credit for what small part I played.
Well, if my memory is correct, and I like to believe it is, you played much more than a small part.
Thank you.
We haven't really talked about incidences or cases that, or awards or anything like that, that you thought were the most important. And so I'd like to give you a chance to talk about
Well, we've talked about cases, and in terms of awards, I would say that the award that I'm most proud of was the Century of Achievement Award, which I received in, I think it's 2000, because it was something the American Bar Association started in our Bar Association, decided to adopt it, and that is to award attorneys who were particularly helpful in their state bar and during whatever century it was. And I was the president and most involved in between 1990 and 2000, so I got, along with Les Smith, we received the Century Achievement Award for that. So I would say that is the award that I'd be most proud of. And in terms of we talked about some trials, but it's interesting when I look back on my career, some of the things that were really the most meaningful to me didn't involve cases or winning or losing cases. Because when I wanted to be a lawyer, my goal was to try to help people. So, as I went along, I learned how to relate to people better. I'm still working on that, and not always very good at it. But I'll give you an example of something that, to me, was one of the best things that happened to me in the practice of law. I was over to the courthouse as the Second Judicial District one day for a motion hearing, and this judge, like all judges, would schedule a half dozen or so motions at the same time, and you'd go over there and wait for your motion to be called. So I went over to this particular judge's chambers, and there were 4 or 5 other lawyers sitting there, and as I sat down, I was struck by what was happening in the courtroom. The judge was talking to a somewhat elderly African-American gentleman, trying to explain to him that he didn't respond to the complaint, and she's going to have to enter a judgment against him, and it's going to be for whatever the amount the plaintiff was asking. And so I got up, I went into the well, thank you. I remember what it's called, the well. I said, "Excuse me, Your Honor, if it's appropriate, I'd like to enter a pro bono appearance on behalf of this gentleman." And he said, "Fine." I said, "Could I have a minute to talk to my client?" So I'm standing at the podium, and I said, "I'm Alan Torgerson." And he said, "I'm Howard Thomas." I said, "Well, it's nice to meet you." I said, and he had this document. So you mind if I look at that? So I look at this document, and he just told me his name was Howard Thomas. And on this document, it said that the plaintiff was suing Thomas Howard. So I said, Your Honor, you can't enter judgment against this man. They sued somebody else who isn't standing here in front of you today. And so I explained that you know, his fellow's name said he was Howard Thomas, and they sued Thomas Howard. And I said, so she said, "All right, I agree with you. So I'll give the plaintiff opportunity to amend the case and get the caption right and get the right person legally involved." And so, long story short, I worked a little bit with the plaintiff's lawyer, and this fellow had been delivering something in his truck. He didn't have any insurance, but it so happened that we finally found out the person he was helping had some insurance. So we got him some coverage, and plaintiff got what they wanted, and my client didn't get stuck with this $1 million judgment or they were trying to get against him. But that's not the end of the story. several weeks later, I'm sitting in my office, and the receptionist calls, says, there's somebody out here who wants to talk to you. So, okay. So I walk out to the reception area, and there's Mr. Thomas with his wife. And so I greet him, say, how are you doing? And fine. I said, what can I do for you? She said, we wanted to give you something. And they handed me this envelope. And it wasn't sealed, so I could see in this envelope was money. So I said, I can't take your money. I told the judge I would represent you pro bono, and I'm going to do that. You keep this, or give it to your church, or do something else with it, but I'm not taking your money. So those kinds of things are the things that really make a difference.
Yeah, and that's a great story.
Probably a good place to end.
Well, maybe.
I can tell you another. This is another, and this is just a personal story. How people can be nice to people. And this is when I was still in practice, and I was coming over to the federal courthouse, and this was back when they wouldn't let anybody bring dictating equipment, cameras, phones, anything into the courtroom. And so I'm going through this, and they had all the detection equipment in my briefcase, and they look at it. You've got a dictating machine in there. I have my little dictating. It says, oh, I forgot to take it out. I said, can you just keep it for me, and I'll get it back from you when I finish my errands? No, we can't keep it. We can't keep your property. So I said, what am I going to do now? Either I'm just going to have to throw it away, and there's a lady who's leaving, and so she had heard this conversation. And so she said, can I help you out? I said, yeah, what did you have in mind? Why don't you give me your dictating equipment? I'll take it back to my office, and you can pick it up. And I said, that would be wonderful. So give me your name and phone number. So I did it, finished her, got my dictating equipment. And a couple of days later, I sent her some flowers. So that's just, little things in life can sometimes be so important.
Absolutely, absolutely. So one more chance. Anything else you want to add?
I think I probably said it enough. But thank you very much. You've been very kind.
All right. Well, on behalf of the Senior Lawyers Division and me personally, I thank you for your willingness to sit and come forward and share with us much of what your life as an attorney and a judge has been. And we thank you very much.
Thank you for having me.
All right.